in which, on a matter of extreme national importance, we've been given 1 hour to be able to do an application, serve it, and come back to court. We have tried to do the best that we could in terms of complying with those directions. Of course, one of the issues that we could not be able to request counsel to give us specific reference to Okio Motata has been mentioned by two counsel, is probably the most prolific litigator in the history of
My lords and my lady, for the Speaker of the National Assembly, we have
kila mtu wako wapi, tutakoordinate aje?
The 9th respondent intends to provide video evidence. We mentioned this because so that to let you know that we received that letter, but at the same time, I think this court is properly moved, not by way of a letter, but by way of an application. And therefore, the advocate for the 9th respondent we will treat that as just a letter.
Record would be argued before the bench to be constituted by the Chief Justice.
Then the applicants will have 10 minutes. Interested parties will give them 5 minutes each, and if senior counsel Mr. Dr. Amir is around, we will consider.
Akolafi Mohammed and another, that any record that you have decided that we hear, the potential content as
it did not impress the court in Kenyatta as an application warranting the type of priority that you're now being told. On the issue of whether contempt, if that argument were told, my lord, we too, the party, for all these dilatory tactics, is because this side believes having obtained a final ex parte order, they can now grind the wheels and backpedal and buy time until the conversion of the Jews, or until, as my people say,
raising issues we believe are serious and weighty. We have no interest in raising frivolous issues. And I believe that is why this honorable court gave leave to appeal. This court will not give leave to appeal against any frivolous points.
Thank you, Senior Counsel.
No, my Lord Presiding Judge, permit me, speaking on behalf of the 9th petitioner, there is a concern that we have in view of the directions that have been shared by my Lord Justice Ndima, and my Lord, the comments that have been made by my senior, Dr. Mutomi Kiankolo. My Lord, indeed, there is a preliminary objection that was served by counsel representing Professor Kithure Kindiki, appeal. And my Lord, just to assist us, I remember in the year 2021, when there was a challenge on the appointment of the Chief Justice, my Lord Justice Brima had, in that instance, given a conservatory order while there was a pending preliminary objection on record. And when the state went to the Court of Appeal, there was direction that was given at the Court of Appeal that when there is a serious attack on the jurisdiction of the authority of the court, especially in view of a preliminary objection, then it is incumbent upon the court to first consider the merit or otherwise of the preliminary objection that attacks the jurisdiction of the court before perhaps we can go to any other matter of business of the court. I have with me, and I will share with the court, the decision that was made after a decision was arrived at by my Lord Justice Mrima and 2 others.
Thank you.
Thank you.
Thank you very much.
To carry out the instructions of our client. My Lord, you have seen the bundle of documents that everybody is having here. This is a court of record. And
I'm sorry to time for the elections.
Let them not be the issue.
Issue conservatory order is to preserve the substrata, the subject matter of the petition. Here, what is being preserved is the rights, constitutional rights of the Deputy President, who has challenged the impeachment for violating his rights, seeks to have that impeachment vacated and quashed. That is what needs to be preserved, and that is the purpose for which 3 judges issued conservatory order, or 2 judges issued conservatory. But my lords, your leadership, those 3 judges sitting separately, each one of them made a finding that there were serious, weighty constitutional issues raised that needed to be fully canvassed during the hearing of the petition, for the court to have the opportunity to give a considered decision on those issues, and therefore gave conservatory orders to preserve the subject matter, so that the Deputy President remains in office. There is no vacuum, there is no insecurity. My Lord, the best guarantor for security is observance of the rule of law, constitutionalism, and the Constitution. And this is the court that has that weighted duty of ensuring that that happens. Lords, the weighty issues identified by the 3 judges are: 1, the issue of public participation. The petitioner here says the public participation was a sham. We will be going into that through my colleagues. I'm just saying the weighty issues here. The second issue was the constitutional validity of Standing Order 68, giving a period of only 12 days to finish the whole purpose of the impeachment. And I would like to mention this issue of public participation, and indeed the time of 12 days, assumed added importance when we remember the wording of Article 1. The wording of Article 1 is that sovereignty remains in the people of Kenya. They have donated that power, that sovereignty, to your lordships, to your leadership, to the judiciary. They have donated their power to Parliament, the National Assembly, and the Senate, and they have donated that power to the executive. But the people of Kenya remain sovereign. That is why there must be adequate public participation in terms of the decision in the British tobacco case. The third issue was proof, the threshold, serious violations of the Constitution, which the Deputy President says do not exist in his place. Our opponents will be pointing out to you where it is that undermining the president is one of the grounds. My lords, the people of Kenya, in retaining sovereignty in themselves, elected leaders, members of parliament, senators, deputy president, the president, to serve them. They are the employers. The deputy president, the members of parliament are employed by the people of Kenya. And therefore, the people of Kenya have got a right to see how the people they have employed are discharging the duties they have been given. We look up to you, my lords and my ladies, to be the bench, what the judiciary is what the people of Kenya look up to hold the country together in terms of observance of the Constitution and of the rule of law. The people of Kenya, in electing the deputy president and the president and the senators and everybody else who is elected, they were not electing to go back to imperial presidency. And it is for this court to ensure that we do not go back to the imperial presidency where the Constitution and the rule of law are replaced by the wishes of one individual. I hand over to my colleague, Elisha.
My Lord, for the record and for the interest of those who are transcribing the proceedings, my name is Elisha Ogoya. I appear for the first petitioner applicant, His Excellency Rigathi Gachagua, Deputy President of the Republic of Kenya. My Lord, I stand here to canvass the Deputy President's application dated 18th October 2024, which in the main seeks that you halt implementation, or put appropriately, further implementation of the resolution of the Senate made on 17th October 2024. Allow me to then also put on record that we have some written submissions that were filed, and I think it's good practice to draw the court's attention to them so that the record confirms that they are part of the record. We had filed some written submissions on 22nd October 2024. We adopt and reiterate the contents of the submission. When we require, we urge you to have a look at them. But we also filed some additional written submissions on 28th October 2024. Both of them are entitled Petitioner's Submissions on the application dated 18th October 2024. Let me move into the substance of what I want this court to consider this morning. And I want to make some overall observations, my lords and my ladies. I prefer to look at this case in this court as an opportunity for our constitutional order. Whereas I know that there may be Kenyans out there interested in this matter, looking at this moment as a challenge to our democracy and a challenge to our constitutional order, I bear a message of hope. I want us to look at these proceedings as an opportunity for our constitutional order. So the challenge for me, my lords and my ladies, is how we shall seize and use this opportunity. I look at it as an opportunity for our governance institutions. My lords will remember the words of the late Justice Chunlan Magwanda Madan in that famous case of Githunguri versus Republic, when he urged Githunguri to run unto the hills, face east, and thank his God that Kenya is a country under the Constitution. I see this as another opportunity. I beseech this court to urge His Excellency Rigathi Gachagua to run to the top of Mount Kenya, face east, and tell the world that Kenya is a country under the Constitution through the opportunity presented by this. I see this case as an opportunity for the judiciary, and I'll be elaborating on this point in a short while because of the behavior of other organs of government in the recent past. So I see this as an opportunity for the judiciary. I see this case as an opportunity for righting wrongs and not for perpetuating wrongs. I have had the privilege of participating in these proceedings from the National Assembly, through the Senate, through this court. And I thank God and thank my client for that, because out of 50 million Kenyans, I have done nothing special to deserve this opportunity, but this somehow fate has conspired to give me an opportunity to participate and witness these events from the front benches. What this case has taught me is just how perilous we stand as a country if we depend on our legislative and executive institutions, and very recently, our constitutional commissions. Our remaining beacon of hope, my lords and my lady, is this judiciary. I have one question for you, my lords, my ladies. Will you drop the ball, or will you hold the ball to the finish line? A brief history of what you will find in our amended petition, by way of paraphrasing, is that on 18th October 2024, this country witnessed an unprecedented hurry by our executive, legislative organs, and our constitutional commissions to beat our constitutional order. I'll demonstrate this shortly. On that day, 18th October 2024, we witnessed an unprecedented hurry. In fact, I would have thought, speaking for myself, that our country has become super efficient. But I discovered that no, we were still waiting long to get our national IDs. We were still waiting long to get our passports. We were still queuing for long in our hospitals for health services. That this unprecedented hurry was for a specified project to beat our constitutional order. And why do I demonstrate this? A process for which the Constitution of Kenya prescribes 74 days at Article 149, Clause 1 of the Constitution was truncated and executed in less than 6 hours. Clearly, we may have varying definitions of the word hurry, but we can build consensus that this one is undisputedly unprecedented hurry. Why did the makers of our Constitution prescribe 74 days maximum in Article 149, Clause 1? Different analysts may give it different interpretations. I beseech you to find whatever the scope of interpretations, the following will fit into them. Number one, it must have been to give the process optimum transparency. Number two, it must have been to give the process optimum accountability. Number three, it must have been to give the process procedural fairness. Because whereas we know that justice delayed is justice denied, we also know that justice hurried is justice miscarried. And finally, it must also have been to give public participation in the process under Article 149, Clause 1, some chance. Allow me to submit at that juncture from the very outset that the process undertaken by the President of the Republic of Kenya, by the Ethics and Anti-Corruption Commission, which was mentioned in the President's communique to Parliament, the National Assembly, by the IEBC, that was also included in the President's communique to the National Assembly, and by the National Assembly itself, did not even pretend to have an iota of public participation. Even the pretense of public participation was now taken away. We will demonstrate to you that the process between 1st October and 17th October, the process between 1st October, when a notice of motion was given in the National Assembly, to 17th October, when a resolution was taken by the Senate, had pretenses, half-hearted pretenses of public participation. That will demonstrate. The process on 18th October, buoyed by any lack of checks, buoyed by the fact that any attempt at checking the institutions had not yielded fruit, now they became brazen. They now undertook a process on 18th October, now completely without any pretense of public participation. There is no single Kenyan who was given a chance to ever say what their take is on Honorable Kithure Kindiki, my law lecturer of yesteryears, and a fundamental scholar, my good people. No Kenyan was given a chance to give any thought on whether or not he is suitable to be deputy president. No member of the public, no memoranda was received, no meeting was called anywhere for anyone to give any thoughts. No email address was given to be crushed by Kenyans, as we now know Kenyans can do it. Completely no pretense at public participation. I'm emphasizing these points, my lords and my lady, to demonstrate the point I made earlier, that we have now been taught how perilous it is for us to rely on our executive institutions and our legislative institutions and our constitutional commissions as defenders of our constitution. We are now left with only one institution, this judiciary. I don't know that noise is from within here. They are doing renovations today because this is so important a day for renovations. And let's face it. Let's face it. The process of 18th October 2024 took 6 hours as a deliberate scheme to defeat each of the principles and values of good governance I have alluded to: transparency, accountability, procedural fairness, and public participation. Who did these violations? We are also here to call people to account. Who did it? Between the time we left Senate around midnight, between the time Senate closed business around midnight of 17th October 2024, and the time we woke up to the presidential communique of 18th October 2024, in that night, the Bishop Oginde-led Ethics and Anti-Corruption Commission is documented in the President's memorandum to have received, processed, and given a clearance to Honorable President that night. My lords, history is important, and I really have to remind you why our Constitution prescribes that our presidents be sworn in during the day. We were all adults, we know where that comes from. It's one of the most autochthonous provisions of our Constitution. And that when things happen in the night, we have reason to have our antennas high. Between the time Senate rose on the night of 17th October 2024 and the time we woke up in the morning of 18th October 2024 to the President's communication to the National Assembly, we were told that the IEBC, which we now know is not properly constituted, has no commissioners, had purportedly cleared on the occupied in the night. I will not say much about KRA, because I think KRA can work overnight and will not complain. But it was that memorandum. The other culprit was the president himself, the president of the Republic of Kenya. Undertook these clearances overnight, and in the morning had a clear, proofread memorandum. Exceptional efficiency, we celebrate that. Then the National Assembly itself. Now this is curious. The National Assembly itself had called a sitting prior to the resolution of the Senate. The sitting was called prior to the resolution of the Senate. To sit on a day, ordinarily not a day of sitting of the National Assembly, to process a resolution of Senate it had anticipated, the removal of a deputy president from office, and processing clearance or approval of another deputy president. We sit here as judges, we sit here as court assistants, we sit here as advocates representing various parties. I don't know who among us, once we take out the clocks of the official role to play, was proud as a Kenyan observing these events as they happen. I don't know who among us was proud now putting on the cloak of citizenship to watch these events unfold at that pace. Fortunately for us, my lords and ladies, we have a judiciary of Honorable Richard Mwongo that arrested this process in its tracks to give the Constitution a chance to roar. In the far corners of Gachagua'S. Fortunately for us, we have the judiciary of Honorable Chacha Mwita, the Lordship, that arrested this process to give the Constitution a chance. Today, you sit and I stand before the judiciary of Honorable Ike Ogola, Honorable Esim Rima, and Honorable Dr. Frida Mugambi that has been invited by the respondents to undo that chance that the Honorable Mwita and the Honorable Mwongo gave the Constitution. We don't begrudge them for that invitation. Because under Article 48, they are entitled to come here and make that invitation. Our question is whether the judiciary of Honorable Ola, Honorable Brima, and Honorable Dr. Frida Mugambi will be baited by that invitation. That's our only question. Through all these proceedings, we shall be looking at you in the eye to ask, will you fall for this bait, or will you stand for the Constitution? Having laid out our broad attitudinal view of this matter, allow me to address you now on the law and the jurisprudence of conservatory orders. In terms of textual prescription, in terms of the prescription of text of the Constitution, we will find accommodation for conservatory orders in two aspects of Article 23, Clause 3 of the Constitution. Article 23, Clause 3 says, in any proceedings brought under Article 22, a court may grant appropriate relief. So we find accommodation of conservatory orders in the use of the phrase appropriate relief. Because appropriate relief is wide enough to accommodate anything under the sun that is necessary to give effect to a right, fundamental freedom, or I dare say, any other provision of the Constitution. The second accommodation is in paragraph C of clause 3 of Article 23, which says, in any proceedings brought under Article 22, a court may grant appropriate relief, including, say, a conservatory order. Expressing I'm a bearer of good news that in determining whether or not to grant conservatory text, to confirm these conservatory orders, my lord, you need not look further than in the files before you. And also usually, just by looking at the files before you, you will see why you must confirm this one. Let me go there. Allow me to address the brief issue of your jurisdiction over this matter from the files before you. I will invite you, when you retire, to look
use this one
at the ruling of your brother Justice Mwita of 15th October 2024 in petition number 550 of 2024. When you look at that ruling, I will invite you to look at page number 7 of that ruling. There is a paragraph 7. The way that ruling was processed was that each theme, the judge addressed it by beginning with paragraph 1 to the last, then another theme, paragraph 1. So you set up paragraph 1, 2, 3, then it ends and get paragraph 1 again. So you look at the paragraph 7 at page 7 of that ruling of Chacha Mwita in petition number 550 of 2024. For the benefit of this court, for the benefit of everybody who is listening, Honorable Chacha Mwita said the following thing in paragraph 7, that the petitioner also argues that constitutional imperatives in conducting public participation were not met. The claim falls within the scheme of Article 165(3), so that this court has jurisdiction to interrogate whether any of constitutional processes said have been conducted under its authority met the constitutional threshold. The judge has already established that the argument on public participation raised by the petitioners falls within the jurisdiction of this court under Article 165, Clause 3. Then, paragraph 9 of that ruling on the same page. Justice Gachagua'S holds, first he observes that the first respondent has pushed an argument that this court has no jurisdiction to hear a matter arising from impeachment of the president or deputy president on the basis of Article 165(3)(c). Then he reproduces the provisions of the article verbatim. I wouldn't want to regurgitate that because we read it. He proceeds now to argue that Article 165(3)(c) is in relation to the process of removing the president or deputy president from office on grounds of incapacity. This process is initiated for purposes of investigating the president or deputy president's physical or mental capacity to perform functions of that office. And here's the danger. This is a distinct process from that of impeachment in Article 145 as read with Article 150. Article 163(c) excludes jurisdiction of this court over the process undertaken in accordance with Article 144 and not Article 145 as read with Article 150 of the Constitution. Honorable Gachagua'S has made a finding that this court has jurisdiction over a matter or a process undertaken under Article 145 as read with Article 150 of the Constitution. If you turn to page 9 of that same ruling, of Justice Gachagua'S of 15th October 2024, in petition number 550, page 9, you'll find another paragraph 4. I think I explained why these paragraphs run back and forth. Paragraph 4, it says, I read paragraph 4 and 5, so for full effect. Paragraph 4, Article 145 lays down the procedure to be followed in cases of impeachment and the timelines for doing so, including affording the person an opportunity to be heard on the charges. I have considered the constitutional provisions on impeachment and read decisions from the Supreme Court and the Court of Appeal, which are binding on this court. These decisions have laid down the position that